Hi everyone, my name is Lindsay Flick and I am the Education Coordinator for the Healthcare Billing and Management Association and your moderator for today's presentation. I'd like to welcome you to the third program in our 2016 Executive Webinar Series, Maximizing Company Value and Client Relations Through Proper Contracts, presented by Jennifer Kirschenbaum. Before we begin, I'd like to address a few housekeeping items. First, today's webinar will be recorded and saved on the Education On Demand page at www.hbma.org. Check out this great recording and other online offerings that we have available. And while you're there, don't forget to register for HBMA 2016, the Healthcare Revenue Cycle Conference, which is being held September 21st to 23rd in Atlanta, Georgia. Second, as previously mentioned, today's program is part of our 2016 Executive Webinar Series. This series provides direct education targeted at senior-level leaders in revenue cycle management companies. So make sure to keep an eye on your email and the HBMA website for dates and times of other Executive Series programs coming soon. Finally, we encourage you to submit questions during the presentation. You can do so by selecting the Question tab on your control panel, which is located in the upper right-hand corner of your screen. Simply type a question and hit send. As time permits, we will answer questions from the audience at the end of the program. And now I'd like to introduce you to today's speaker. Jennifer Kirschenbaum is the managing partner of Kirschenbaum & Kirschenbaum's Healthcare Department. Jennifer devotes her practice towards assisting practitioners and billing companies in all aspects of private practice, Article 28 facility formation and operation, as well as hospital-based practice and hospital relationships and arrangements. Jennifer serves as counsel to many HBMA members and specializes in representing billing companies in their contracts, compliance, and collection issues. Jennifer also regularly handles sales and purchases and employee issues, including contracting and remote workforces. With that, I would like to welcome Jennifer to today's webinar. Welcome, Jennifer.
Thank you, Lindsay. Thanks for having me today. It's my pleasure to be presenting again to HBMA, one of my favorite organizations. Before I get started, I'm just going to very quickly go through what our firm does, so this way you know what questions you should be asking me about. Lindsay gave a great introduction for me, thank you so much, and gave an overview of what we do for billing companies. But pretty much we serve as general counsel to billing companies, and we're very familiar with the industry, because on the flip side, we also serve as counsel to many of billing companies' clients, MDs, DOs, PTs, DCs, DPMs. I could keep going with acronyms, but pretty much all healthcare practitioners we've worked with, all different types. We get involved with, myself specifically, with compliance and transactional issues, so contracts, and also I handle personally audit defense work and some of the leasing elements. The rest of my firm, we have about 15 attorneys, handles litigation matters as they come up and real property issues and also collections. So what does that mean? It means that we see a smattering of issues that come to the fore for our clients on a daily basis, and we like to serve as a resource, which is why we do these types of educational activities, so that way we can share some of our knowledge for things that we think should be common industry information for you, which we provide for our industry representation, which for my department is for billing companies, coding and credentialing companies, and also to our healthcare practitioners. So today's topic is very exciting because I love to tell you about how you can make more money. It's one of the best parts of my job. Very few lawyers have a positive career, and mine actually very much is. About 50% of the time I get to do positive planning, which is a lot of fun. I like to think of myself partially as a builder in addition to just being a qualified paper pusher. So today's agenda is going to be talking about maximizing value of your company. And I think this is such an incredibly topical title and information, because what's happening in our industry that we're seeing is really a ramp up in acquisitions. And if you haven't heard about this yet or seen any of your competitors possibly be gobbled up by a bit of a bigger billing company or possibly a private equity firm, well, it is going on in the industry. I know we've seen topics and speakers at HBMA at certain conferences that I've been at. They've brought in some excellent speakers to talk about how it's going on in the industry as well. If you're not approached or you haven't been approached, you may be. So this talk is supposed to assist or at least get you think about how your current day-to-day operations impact your actual value and saleability, and what we can do to get you in a position for your company to be better positioned to be worth more. Not necessarily if you're going to sell, but just in case down the line, just so you're aware. And also it's general best practices we're going to be speaking about too. So our agenda today is talking about your company value and specifically your contracts, how we're going to maximize value through our client contracts, tips on getting people to actually sign our contracts, and then we're going to talk just briefly about compliance, and we're going to end with just a summation about the sales process so we can talk about how it all comes together when you're approached by a potential acquirer. Oops, sorry, going too fast. So company value, just so we understand how the value of our company is measured, many of us may be aware, but it's done typically by EBITDA, which is just the acronym is earnings before interest, taxes, depreciation, and amortization. So basically that's just your revenue that's coming in. And when you'll hear that acronym passed around, if you do have a larger company or possibly a private equity firm looking to come in and buy your entity, they'll ask you, what is your EBITDA? And it's basically, what was your gross revenue? What did you bring in this year? So let's say that that's $100,000, or better yet, let's say it's $5 million, okay? That is not your sales price. You're going to want a multiple of that. So how do we determine the multiple of EBITDA? Well, that's going to be based on your actual operations. How much of a right to revenue do you have as a business owner? How locked in are you with your customers? And what type of liability do you have hanging out there? And we'll get into some more of these questions as we come to a summation, but the multiple is going to be different depending on how you operate your business on a day-to-day. So we want to try, I want to try as your counsel to make sure that you're operating to get the highest multiple on sale, because that also means, in my mind, that you're operating as compliantly as you can and also make money, and you're also operating in a best practices manner with your clients and with presumably incredible transparency and not a lot of potential liability hanging out there. So to get started, we're going to talk about some basic contract terms and how I view these terms as, again, maximizing the value of your company. I'm going to go through all these terms today. We're going to spend more time on some and less on others. And then we're going to talk about applicability. I'm going to show you 2 case examples that are going to explain how these contracts actually come into play when they're challenged or when you need them on the defense. Many of us do actually have contracts in place with our customers, but you're going to see as we go through, if you actually pull up your current contract that you're using as a form, you'll find as we go through our provisions today that your current contract may or may not have in detail the elements that we're going to discuss today, and you may decide after this discussion that it possibly deserves revision, and that's obviously your decision as a business owner. The services that you list out in your contract should be very specific. So many times when I review a billing company's services agreement, it'll start out and say, we will be providing billing services. And it doesn't necessarily get into the list of what you expect from the client and what they should be expecting from you. Other of my clients actually do have or even attach a schedule of specific items that they will be requiring, demographic information, whether they want the super bill from them, or they'll get specific on who's doing the coding and who's not doing the coding. The transparency in your contract will save you at a later time. I would like to see, with as much specificity as possible, your services delineated and what you expect from your client delineated. If you're not doing any coding work at all, you're requiring the healthcare practitioner to determine the codes before you submit, please make sure that that is written into your agreement. Why am I trying to hammer this for you? Because there's incredible exposure right now with audits, whether that is going to be from Medicare or from a private payer who's just looking for money back, or if it's a Medicare possible referral to the Office of Inspector General or to a U.S. attorney. We want to make sure that your liability is limited. The more liability you take on, the more risk, and again, going back to value, the less that I believe you'll be able to demand from your company because you've taken on a lot of risk and there's potential a lot of exposure. So Let me put this into terms of a sale. If I were representing your company and you were making a tremendous amount of money on your monthlies, which I call recurring monthly revenue, is very, very high. You have a lot of clients and you're making a lot from them. But you have practices going on right now that are not necessarily on the up and up, and you're changing some codes, or you're doing whatever. You may be able to get a very high multiple or purchase price for your company, potentially, because someone may want your client list, but they may not be willing to accept your contract. And when we get down to it, the nitty-gritty, in the purchase agreement, they may put in a very, very hefty period of time that you're going to have to indemnify them for if there is exposure. And what that means is that just because they're paying you a lot of money doesn't mean you're going to be able to keep it. They may require a large amount of it posted in escrow, and then they may require a large amount of it to be clawed back, or maybe even all of it to be clawed back if within a certain period of time there's an audit that results or an investigation, and it's because of the practices that you had going on while you were owning the company. So just because you get that big number doesn't necessarily mean you get to keep it. So how do we combat this on the day-to-day right now preventatively? Well, we get very specific about what we're doing for our clients. If we're not doing any coding work at all, we want that in our agreement. We want to make sure that we're going to show that our doctors or other clients, miscellaneous healthcare providers, are responsible for making the coding designations. And we do that by making it clear in our client services agreement that we are not taking on the responsibility for the coding. So that's one example of how we get specific. The next example, I have a lot of healthcare providers complaining to me that their billing companies are not resubmitting fast enough for an audit process, or they're not rebilling, or they're not following up on collection efforts. Well, if you don't plan on doing any of those services, if that's not part of your standard course, or if they have to pay more for that, then you need to make sure that that's specific in your contracts as well. You want to make it really clear exactly what it is you're doing for the money that they're paying you. So that's the first tip that I can give you, and I think it's very, very important that we all take a look at our services and make sure that we feel that what we plan on doing is what's reflected in the contract. The next section, typically, that comes on is our fee structure, is how are we going to be getting paid? Are we getting a flat fee per claim or a monthly rate, or are we charging a percentage? Obviously, the industry standard is to receive a percentage fee. Now, plenty of states say that a percentage fee is illegal. So what do we do about that? We're working on, really, it should be an incentive basis, because if they get paid, we want to get paid. Most states, even though there may be language out there that fee splitting is illegal, which the way that reads in New York and also New Jersey and a bunch of other states that I could name, is that a healthcare practitioner is not legally allowed to share fees that it has coming in from a payer with a third party. New York State and other states have case law out there that has specifically exempted billing companies from that definition. And it basically said that if you are rendering services in a capacity as a billing company, you're essentially operating as a necessary administrative person, and that the fee splitting laws were really meant to have practitioners refrain from referring or getting paid for referrals and kickback relationships. So I feel very comfortable with a percentage-based compensation model. I haven't seen it challenged in a way that I think creates a substantial amount of liability for a billing company or an unacceptable amount of risk. That is speaking in terms of a billing company taking an acceptable percentage as in the industry, which I've seen is below really 12%. I know some people charge upwards of 12, maybe around 14, but most of the contracts that I see are really generally, I would say the mean lands around 7, 8, 9%, and certainly 5 is not out of the question. I've seen around that level as well. So in our fee structure, we want to decide how we're going to be charging. Obviously, if there's more potential upside, I would like to see that because it maximizes your value. Another way that you could possibly do it is if you're dealing with certain client base where you understand that you have to give a lower percentage to get the work, you know that as the claim goes further along in the process, you have to work harder. Well, you may want a higher percentage. If you're taking hospital work and they're wheedling you down to a 3.5% billing fee, well, if you get an initial denial, you may want to consider structuring into a deal a higher percentage for claims after initial denial, or possibly if it goes into the collection stage. And many of you, I know, have relationships with collection agencies and possibly law firms, and that's a whole other scenario which has to be addressed in your contract on who's getting paid what, who's responsible for the fees, how is the money supposed to flow through if there is a collection, and how, at the end of the day, are you going to be getting paid. So we want to make sure that's the case. Also, many of us already know that industry standard, a lot of our colleagues are requiring to be paid on cash collections, deductibles, and co-payments at the door, not actually on just the money that they're responsible for collecting through submission. So that's another concept for you to make note of. If you're already doing that, we'll move on. Hopefully I'll have some other tips you haven't heard before. Term and termination. The longer the contract, the better. Now, depending on which jurisdiction you're in, state or even sometimes local municipality, there may be a prohibition on having a contract that's longer than 3, 5, or 10 years. Obviously, we would want to see that checked on a local level. In New York, it's not unusual to see a 5-year contract. I've even seen 10-year contracts. And throughout the country, also 5 years I see is very standard. Some of our jurisdictions in this country, because of consumer protection laws, do not allow automatic renewal. So we want to be careful of that. But I would like to see, if your jurisdiction allows it, a longer contract, 5 years preferably, and then I'd like to see an auto-renew. Contracts I see with an expiration date are just a bad idea. Obviously, from our perspective, from the business owner's perspective, we want to see the obligation continue. And this is your right to recurring monthly revenue. And having your contract in place with a long-term client is what's going to allow you to receive a higher multiple and higher value on your company. Right to terminate. Obviously, what I'm saying here should have already resonated, that we don't want our clients really to be able to get out of our contracts very easily. That being said, we have to be a little reasonable, I believe, if you want your contracts to be signed. So I would recommend that we have a bilateral termination provision where both sides are allowed to terminate on an equal number of days' notice. And in addition to that, an easy way to get yourself sued is to not address the wind-down provision. So what is a wind-down? Well, a wind-down is a period of time after the termination or notice of termination where we will continue to work claims, possibly not accept any new claims, which would be written into the contract, but continue to work additional claims so that way we're not leaving the customer high and dry, and we will agree to continue working on claims that have already been put in process and are still outstanding. So what about if we're not being paid? Because I've heard this before. And that's a tough question, because just because your customer is in breach does not necessarily mean that you're going to be right for abandoning the work. So two rights don't make a wrong. And in that situation, I would recommend that you reach out and we have a discussion on what the exact circumstances are, and we see if we can come to a resolution with the client. But certainly, you are holding them in a very leveraged position. If they're expecting you to work their claims, definitely we would first start by making a written letter demand that the payments be made and that you be brought current in order to keep working. On that note, certain of my clients definitely do put into the wind-down provision that if they stop being paid or if an auto-pay right is taken off, then they will no longer be responsible for doing work. Again, that could be in the contract and it may be upheld, but we should speak if that's the situation you're not being paid. Representations from both sides, from the billing company and also from the client. We want to make sure we're really clear what we are telling them we're willing to do. And we're going to hit some of that in the services section, which we've already covered, and then we're going to hit more of it here in the representations. We're going to make the representation that we're properly formed, that we're duly operating appropriately. We'll probably say somewhere in the document that we maintain compliance. And then we're going to require the client to give us a number of representations on their end, that they carry appropriate insurance, that they're appropriately licensed. We're going to want representation as to how they do their business. And this section is incredibly important because without having the reps from the client and without you telling them what you're responsible for, again, it may be a question that remains outstanding, possibly requiring litigation to determine whose responsibility something was. And we want to make sure that that is not going to fall on us later. We want to make sure we have a prenup in place, because a prenup is a lot safer than a messy divorce. So that's part of the representation section. Another area that we want to make sure we hit, because I know many of us outsource, we want to make sure that in our services agreement, our clients know we may be sending things outside. Why is that important? Well, I want to be really, really careful here, because I think we are, I know we are just seeing the beginning of liability for billing companies and other business associates in their interactions with covered entities, which is any healthcare practitioner. And what do I mean by that? Well, the government is starting to look into these relationships more so because they see money there, whether it's through HIPAA violations or through False Claims Act, money that's being submitted to the Medicare Medicaid system. There's definitely a higher level of inquiry and scrutiny by the government. So what does that mean for subcontracting? Why am I bringing this up? Well, if you haven't disclosed to your client that you are subcontracting, then I am very concerned, and you don't have the authorization to subcontract, that any exposure or liability created by the subcontractor is going to fall on you because they would have not knowingly signed off on it. So I want to make sure, really clear, if you're outsourcing anything, outsourcing to another company here or outsourcing possibly to India or the Philippines, please make sure that our clients know we're subcontracting. No, you do not have to disclose where to, but just make sure that they know and they sign off. You have the right to subcontract. And then in addition to that, we're all going to want to take a look at our relationships with our subcontractors because, again, going back to maximizing the value of our entity, we are only as strong as the potential liabilities out there to cut us down. And if we have a subcontractor out there that's working on our authorization and we do not have proper risk-shifting provisions in our arrangement with a subcontractor, then at the end of the day, we may be left holding the bag for actions of the subcontractor, potentially. I know I'm speaking in broad range generalizations now because we're not specifically looking at contracts between subcontractors and billing companies. We can do a whole other discussion on that another time, but we want to make sure that we're protected as we enter into those relationships, and we want to make sure that any liability of the subcontractor is not going to flow through to our company. Very, very important. So next up, I want to give you a real-life example. This is a case example. It's a 2011 New Jersey case of a billing company using their contract to collect. A billing company sued their client for underpayment and lost opportunity damages. So what does that mean? They're claiming they were underpaid. They had a contractual rate of getting paid at 5.5% for all collections, and then they specified in the original agreement that if they were still working as of, I think it was 2007 or 2008, that number would go up to 7.5 of collections they would be entitled to. So this agreement didn't end until closer to 2008, actually. So they had an underpayment amount that they were due. In addition to that, they had into the contract a provision that while the billing company was working and the contract was in force, in effect, the client was not allowed to engage the services of another billing company. Well, the billing company sent the client a notice saying that they weren't being paid, so they were going to suspend services. So listen to what happened here, because this goes back to the suspending of services. They then sued for their amounts due, and the client moved the work. The contract was never terminated. That's what the judge found. No one actually properly terminated the contract pursuant to its terms. They didn't send a notice by certified mail if that was required. So it just remained in effect. So the judge found that the billing company was right and awarded them $420,000. It was 100% recovery on the underpayment request, which was in the lawsuit. And then in addition to that, there was another large award for the diversion of work because they found the provision of the contract to be valid, that the claims were diverted to a competitor in violation of the exclusivity clause. So this is an example of if we have a good contract, one that we can stand behind and rely on, we can actually get paid on. So think about the provisions that you have in your agreement and make sure that they're in line with these types of concepts, which is when we went through the collection portion of the contract already. So if you have any questions on that, feel free to ask me at a later time or we can try to answer today on the webinar. I'm going to get into some defense provisions now. These are equally as important in valuing your company, because even if it's not as substantive in your mind as money that's coming in the door on a monthly basis, knowing it's going to hit your bank account because you have X number of clients and you have X number of recurring monthly revenue. The defense provisions are a little sneakier, because this is what protects you from liability that may be out there, this ominous threat of potential litigation from your customers or clients. And we want to make sure that we have these provisions in here to protect you going forward. An exculpatory clause is not in many of your contracts, but it is a concept that's upheld in the majority of states. It's an incredible legal concept that allows you to actually contract away your own negligence. Jennifer, did I hear you right? Can I actually contract away my own negligence? Yes, you can actually contract away your own negligence. We are allowed by contract to shift risk. Here, we can actually put language into the contract that says that if you were just negligent, if you accidentally threw out some of the claims, or you lost the patient demographics, or it wasn't gross negligence, which is very hard to prove, or willful misconduct, which also is a very significant standard to have to meet, then possibly you won't be held responsible, assuming that you have this language in here. And this clause is going to play in with a lot of other clauses we're going to go through today, so that way, if you are sued, let's say, for not submitting a whole bunch of claims for a client and they think they lost a lot of money, well, if you have this provision in your contract, this provision may work to get you out of trouble. And if it doesn't, then we just go down to the next provision, which we're going to talk about next. So the way that an exculpatory clause works is it reads that a billing company is not going to assume any liability and shall not be liable to the client for any loss sustained as a result of billing, coding, or documentation error. Now, I want to go back to this language quickly, the billing, coding, and documentation error, because, again, we definitely should not be responsible for any coding error if we are not doing any coding. Okay, so this language wouldn't be in here, actually, or maybe I would decide to leave it in. I have to think about it, if we were not doing any coding work. The documentation, for sure, we should not be responsible for any documentation whatsoever. And in the reps and warranties section, also the services section, possibly elsewhere, we want to make sure that we've peppered in that the client is responsible for any and all documentation. All we are responsible for is generating the billing forms and submission. We are not going to be responsible for any documentation whatsoever. So we want to be really clear. In the exculpatory clause, we're going to tell them that no matter who prepared it or whatever the clause is, we are not responsible at all. And we're going to move on. Next. Now, I have product liability in here as well, because some of us may be offering an EMR platform, so that would be a product liability potential claim if the platform goes down. If you are offering a software, we do need to make sure that we have clear protections in there from downtime and service and anything like that. So you should speak to me about that after if necessary. Limitation of liability is a provision that many of you do have in your contracts. I've seen it a lot. The way that it works is basically it fixes an amount, whether it's a multiple of what you are making off of the client or if it's an actual tangible number. And it says that even if you are responsible, you're only required to pay this amount. So what I recommend is that if you have a liquidated limitation of damages, limitation of liability provision in your contract that says you're only responsible, let's say, for $250, that's not tenable, okay? Because you're making a percentage of revenue that's coming into a business. So typically what I see enforced, and we're going to talk about this a little bit later in a case example, is you should do it as a multiple of what the client is paying you. I think that that's a lot easier to stand behind, because you're not warranting yourself as an insurance company. You're not taking responsibility for the full amount that the client is due, but you do have to have a reasonable level of responsibility based on what you're being paid. And that's what I see in the case law that comes down. And if we can cap our liability, this is something that happens when a company comes in to look at you, to value you, to see how much they're going to pay you, what your company is worth. They will look at your contract and see which of these protected provisions are in your agreement. And they will give you more credit for the value of your contract, which increases your multiple exponentially if you have these protections carefully crafted into your agreement. And that's the truth. You can speak to any potential purchaser and they'll tell you that's part of the diligence process. Another defense provision that you'll see peppered all over the place in all contracts is indemnification. This is a risk-shifting provision. it allows you to contract away your responsibility for damages caused by you or any employees or any third party you're related to, subcontractors. You're moving the responsibility to the client, and the client is going to hold you harmless, meaning they're not going to come after you. And also, if this damage does arise, the client's going to pay for it. So this is an area where I'm very interested in risk shifting, and you'll see it again when we talk about a business associate agreement a little bit later, because of what's going on right now with HIPAA. We, each of us, are custodians of protected health information that our clients are giving to us in order for us to do our work. That puts us in tremendous exposure. And mostly, I believe that exposure comes from actually our employees, which we may talk about a little bit today, but possibly another time. So heightened exposure from the Office of Civil Rights, which actually I think I will get to on a slide a little bit later we'll talk about, so I'm going to keep going. Fee structure as well. If your client is asking you to work on a percentage, then we want to make sure that they're taking responsibility for that election as well, potentially. As I said, I don't really believe that there's much exposure out there for structuring in a percentage as opposed to a flat fee model. Okay, insurance procurement provision. This is where we get the we put the responsibility on the client to make sure they're maintaining certain insurance policies. One that I think is interesting that you may want to actually start adding, most of you don't have, is a data breach policy. You could now require that your clients get an insurance policy to protect against HIPAA exposure. That's a great idea because we can also have them name us as an additional insured, which is going to allow you to remain protected. And it's going to be one more thing that you can put on your checklist of positive things you're doing for your company. We're also going to make sure that the insurer is going to indemnify and hold us harmless. So that basically will mean that the insurance company won't have a right to sue us if we're the one who causes the damage that they have to pay for the client. And that's actually considered, that's called a waiver of subrogation. I'm not going to get into exactly what that means, but that's essentially what it is, and just explain it. The next provision we're going to get to, and this is the last defense provision that we're going to go over, and then I'm going to move into some other concepts and try to leave some time for questions. I also know many of you are on a lunch break, so I'm trying to be brief, is our legal action provision. And this is usually in your miscellaneous section. So if you have your contract up right now, that's where you'll find it, typically. And what it talks about, it's easy to just kind of overlook and glaze through, but it talks about what happens if there's a dispute going forward or at any point in the contract. How's it going to be handled? Well, we want to know if there's any limitations on a client's right to sue you or vice versa. We want to know if there's limits to the type of actions that can be brought. Is it limited to breach of contract actions? We want to know whether or not there's going to be attorney's fees that are built into a recovery. Is the prevailing party going to be required to pay? That's typical. Are we going to waive a trial by jury? Yes, I would recommend that. And I would recommend that we prohibit counterclaims. Arbitration is an option. Sometimes, depending on which arbitration company is selected, and you do typically specify the arbitration company, it may be just as costly as litigation. So, and litigation will allow you to get injunctive relief, immediate relief, so you may not want to actually specify arbitration, but that's something we could discuss. Very important and happening right now to one of my clients on the physician end, actually not on the billing company end, is governing law and venue. This is very, very important. You want to make sure that your company is located in a state where you have preferential laws for your company and protection. So we would like to make sure, number one, that we are in a state that upholds indemnification, that has the right to limitation of liability, okay? We also like to make sure that we can use the exculpatory clause for our benefit. So how does this work out? It's not based on where you're actually located, the governing law and venue. It's actually based on specification from contract. But where you can sue someone is located based on where the companies are located. So for many of us, we're going to pick governing law and venue for our home state. And that may not necessarily hurt us, but it may actually end up hurting our clients, which is, frankly, to our benefit at that point if we're in a litigation. So we're going to mainly choose our home state. We're going to hope our home state has positive law for us, and if you wanted us to check that for you, we're happy to. And at the end of the day, if our clients are out of state, which they may be, then they're going to be at a significant, substantial disadvantage if there's a dispute about this contract. So do not misinterpret or get this wrong. You will absolutely be holding the ace in your hand here if you're located in a different state as your client, because you're going to make it very, very difficult and essentially untenable for them to contemplate a litigation with you, because it's going to be very disruptive for them. There's going to be travel required. They're going to have to trust a lawyer from out of state. So I'm not saying that they won't do it, of course, but I think that there's some additional thought, even though there's substantial consideration before you participate in or start or cause someone to file, as it may be, a litigation. You may take even more pause if it's out of state. So there's that. So if your client is asking you to change to their state, that's something I would hold on. This is an example of defense by contract, and I think it's an important one to go through. This is Darby Anesthesia Associates versus Anesthesia Business Consultants. Here, the doctor sued the billing company for failing to perform. The billing company supposedly, allegedly, failed to rebill. They were too slow. There was a failure to bill certain surgical procedures, and the doctor felt that he was owed a substantial amount of money, a couple $100,000 because of this. That's what he lost out on. The contract had a limitation of liability provision, and it capped the liability at 3 times the average fee, which is approximately $25,000 a month, so capped it at about $75,000. The practice claimed that they shouldn't have to pay, they shouldn't be capped at the limitation of liability amount because the provision was unconscionable. Or, at a minimum, the billing company should be required to utilize their best efforts, or commercially reasonable efforts, not best efforts, to correct errors and omissions that they had previously made before the provision can apply. The judge threw out the practice's argument, and he said to the doctor that actually liability is not going to be capped, and this is why. Because the billing company that was actually in Pennsylvania, the client was in Pennsylvania, was using Michigan law. And Michigan law explicitly allows parties to avail themselves of the limitation of liability provision by contract. And the court went to go look at whether or not this provision should be treated as unconscionable. Under Michigan law, and I'm sorry if this is too academic for some of us, but I think it's important for you to see where this goes, a provision will only be unconscionable if it meets the two-pronged test. What is the relative bargaining power of the parties, their relative economic strength, and the alternative sources of supply? What are their options? Do they have options? Were they forced into this contract? Then, is the challenge term substantively unreasonable? The court found on the first prong that the doctor was sophisticated and experienced. He had an option or opportunity to engage 3 other billing companies. He'd gone through a couple of months of vetting, and he chose the defendant. The doctor then also spent the time to negotiate certain terms into the contract. So he certainly had an opportunity to review because he asked for reports, and then he negotiated in a salary for his manager. I want to pause here for a second because some of your clients may ask you to do things like this, to pay a salary for an individual to practice, or to provide an administrative person at their location to help them process. I understand that you may want certain accounts, but please be aware of the anti-kickback statute, which is a very scary, very teethy statute that says that we are not allowed to pay when there's potential upside from a federal payer. And this is an easy way to get your company in a lot of trouble just for an account. Please do not offer services without fair market value. So in other words, if you're owed 5% or 12% on a job to perform billing, please do not provide free staffing to the client. It will just be viewed as an inappropriate gift and incentive for you to get your hands on money that at the end of the day can eventually be traced back to, not even difficult way to trace back to, but trace back to Medicare. And that's an easy way for you to become one of our poster child of exposure with the federal government, because there's a tremendous amount of review going on. So please don't do that. Don't offer inappropriate incentives. But back to our prong test. The doctor knew what he was doing. He had time to negotiate it. He negotiated inappropriate things. He obviously takes a lot of risk. Then the court moved to, does the provision shock the conscience? The billing company received a monthly fee of 5.5% of revenue collected in exchange for limited liability exposure. The court actually says this company wasn't making a lot of money comparably. They actually could have probably been charging a bunch more. And we're going to say that the reason why they took a lower end in the industry fee is because they weren't willing to take a lot of risk. And because they weren't willing to take a lot of risk, and because these provisions are enforceable, and because the doctor knew what he was signing and he had an opportunity to negotiate, and he's an intelligent guy, he knows better, yes, you're entitled to your money. So you're entitled to keep your money, rather. So they held the contract true, and the reward to the physician would be capped if you were entitled to recover at the limitation of liability provision, which is 3 times the monthly. So moving on, I hope that was insightful for some of us. I want to give you some tips on how to get our clients to actually sign our contracts. Our clients don't like to read, and they're busy. Some of them will just sign whatever you give them, and many of us know that this is true. Also, if you're thinking as we go through this, oh my God, do I need a new contract? I think I'm actually jeopardizing the value of my business. Well, the good news is also is that if you actually mailed out new contracts to all of your clients, you'd probably actually have a surprising number of return rate where they would just send it back signed. So that's interesting. We found that as well, that about 50% of customers will just mail back the new contract because they're busy and they want you to continue servicing them, and they trust you. So and by the way, these provisions that we're going through, I don't want you to think that I'm trying to tell you to pull the wool over your client's eyes. By no means. I think that you should be entitled to certain protections because you're not getting paid in a way to provide insurance services. And if you're transparent in the services that you are actually providing by the contract, then a client shouldn't have any trouble signing the provisions that we're speaking about, unless they're looking to shift their risk and operations over to you, which is not fair. To give you a real estate example, if you don't own the building, why should you, and you don't access the roof, be paying for new shingles? That's just increasing value for the landlord, and you as a tenant are not receiving the benefit. That's the same thing here. You're not getting paid enough to take on the risk of operating a medical practice. What you are getting paid enough for is to take on limited risk, limited from your limitation of liability provision, based on the services that you're actually rendering, and that you're rendering well with due diligence. And if there is some level of exposure because of basic negligence, then you're also insulated from that as well if you have a small contract. So we can replace our contracts, send them out, see if they get signed. If someone wants to negotiate with us, they aren't happy with the provisions that we've set forth, and they actually want to speak about it. Well, here's one thing that I can tell you. You should not have any of your sales force negotiating legal documents. That's an easy way for you to have contracts coming back to you. Once you authorize someone, you don't have much control after that over what they're willing to cave on, and it's not their company at the end of the day. So if you have staff members that are responsible for this, going out and having these contracts signed, please do not authorize them to negotiate on your behalf and to give in on certain provisions here or there. That's not what they should be doing. You should be taking a strong stance stating that client contracts are only negotiable at the highest level, and in addition to that, if it's legal provisions that are going to be negotiated, you should speak with your attorney about it before you have any accommodations made and understand the ramifications of a change. Once you tell a customer you're not authorized to make changes to the contract, you have to go through your lawyer, that 50% might actually jump up to 75%, because we all know that your clients are not looking to call their lawyer and get them involved in this contract. Some of them will, some of them won't. They may just be willing to sign it. And then once you get the attorneys involved, we can have more of a diligent conversation. And obviously, your attorney should be versed in the legal protections that are out there by state. So if a court is willing to enforce certain provisions, we have a better argument, of course, that they should be accepted in that jurisdiction and your client should be willing to sign it. So you want to be able to go through the protections with them, and the way to do that is always to send it back to your counsel. Okay, so those are my tips I have for obtaining client signatures, and you want to be careful how you do it. Always make sure you have a signed contract on file. A lot of times I see contracts sent out, work starting, and then the contract's not returned. Always make sure you have a contract on file. An electronic signature is just as good in my mind as an original, assuming that we can prove that it was actually the end user or client that has signed off on it. Maximizing value through compliance and risk shifting. We've already talked about this concept going through our contracts, but it's very important. We can push the risk of our services onto our clients, which is what we should be doing, because what we're responsible for and what they ask us to do are very different things. We're responsible for claim submissions for the most part, many of us on the call. We are not responsible for the documentation generation, and we shouldn't be responsible for coding. The clients can't push those on us. They try to. Do not allow them to by contract. If on the day-to-day you get mired in certain issues and make you uncomfortable, that's your decision whether or not you're going to tell the client that it's not your place. But at a bare minimum, we need our contracts to specify what it is and what we are not responsible for. We've gone through the service agreement. I want to touch on the business associate agreement briefly and our privacy policy and employee protections. Our business associate agreement, which I may have a slide on, I forgot, is our document that is separate and apart from our services agreement, and it explicitly covers who is responsible for patient information. We are responsible for it in the capacity that we take it on and have it on our premises. We want to make sure that we have only the minimum necessary to do our work on file. Everything else should be properly purged. We all are familiar with business associate agreements, so I'm not going to spend too much time, except I'll say, please make sure you check your business associate agreement. If you do not have an indemnification provision in there, shifting the risk of patient information to the client, you need a new business associate agreement right away. There is tremendous exposure with HIPAA. Please make sure you have a proper agreement. If you're not sure, send it to me and I will be happy to tell you. Privacy policy. Internally, we need to have compliance, and this is going to help you maximize your value. If you have a potential purchaser coming in that has industry knowledge and is educated, they're going to require to see that you have internal policies governing how you treat protected health information. They're going to want to see your compliance plan. They're going to want to see your employee handbook, your employee training manual. They're going to want to know if you do it on an annual basis. They're going to want to know if you paper who has access to what information, and if you paper who has access to what technology, who's taking technology out of the workplace, who's working remotely, and have we entered into risk-shifting agreements with our staff. Our biggest exposure, many of you have heard me say it before, are our employees. They are the ones who can sink our company from a whole bunch of areas, and I'm going to touch on a few of them very quickly right now. I've mentioned the Office of Inspector General. I've mentioned the U.S. Attorney. These are, for your purposes, the Medicare police and the Medicaid police. These are the ones that are monitoring to make sure that we're not submitting inappropriate claims and we're not profiting inappropriately, or our clients aren't, off of the Medicare program. They are very, very active right now. Why? Because they're following money. They're looking to make money for their states independently, or OIG for the federal government. They're recovering taxpayer money, and they get big headlines when they arrest a big doctor or they bust a big syndicate of billing fraud. And each of them now, every state that I'm aware of, has dedicated specific departments to following healthcare funds and trying to capture back money for kickback and false claims and civil monetary penalties. Similarly, the Office for Civil Rights is the HIPAA police. We're going to talk about an example on what authority they have right now. Their mandate has changed. Many of you have heard our HIPAA webinar that's on our site, or you've seen me speak before about HIPAA. This office used to cooperate and be about proactive compliance and preventative, and they were not mandated to fine. That changed a couple of years ago. They now are in it for skin. They are looking to fine and recoup money from entities that are not HIPAA compliant. And we're going to talk about a business associate that got busted in a second. Tax authorities. The Department of Labor and also the IRS and the local taxing authorities are looking at employee classification to see whether or not taxes are being paid correctly, and also other employee issues like overtime and things like that. So we want to make sure that we know who's watching so we know what we're supposed to be preparing for. And preventative compliance seems like it's too much, it's overwhelming, but actually once you get into it, you realize there's only a couple of areas that you really have to focus on, and you can knock it out and make sure that you're operating to the best of your ability to maximize your value to make sure that we have less exposure. Here's an example of exposure. This is new. This is actually, I think it's a 2016 matter. Catholic Healthcare Services, the Archdiocese of Philadelphia, was a business associate. They failed to safeguard nursing home residents' protected health information, leading to a $650,000 settlement with the Office for Civil Rights. Now, what happened here? It must have been big, right, Jennifer? There's $650,000 worth of exposure. No. A mobile device was compromised. It was stolen. So what does that mean, a mobile device? To me, that means a cell phone. That means an employee had patient information on a cell phone, and the cell phone was stolen. Why was there such a large amount of money due to the government? Well, they probably did not have any policies or procedures in place, and they also probably didn't report. You have a duty to do both, to have policies and procedures in place to track who has access to what information, how are they able to utilize it, who's responsible for telling who if there's a theft or something is missing or accidentally sent out. You need to have that in place. The government specifically tells us what they're looking for here. This is actually in the notations from the press release from that recovery. And here you see the director stating that a business associate must, and this is new that they're saying this, must implement the protections of the HIPAA Security Rule for the electronic protected health information they create, receive, maintain, or transmit. This includes an enterprise-wide risk analysis and corresponding risk management plan, which are the cornerstones of the HIPAA Security Rule. So the HIPAA Security Rule requires each of us have policies in place, that we train, that we have administrative, technical, and physical safeguards on our electronic devices that are used to access, maintain, receive, store, whatever, electronic health information. And if you want more information on this, I can send you out more information on the security rule. But absolutely, we need to have our privacy plan in place. We need to do an assessment of our risk. We need to have our employees under contract, and we need to make sure we're protected. We also can buy insurance in this area too. And I would recommend you look into all of these areas, because when you talk about maximizing your business value and limiting potential exposure, this is a big one. When a knowledgeable company comes in and looks to vet you, as part of the diligence, they're going to ask, do you have any known liabilities? Have you been sued? Are you under investigation? Can we see your policies and procedures? Show us your compliance. And all of these things that I just mentioned that are probably giving you a headache, they are all going to come back to haunt you when it comes down to the bottom line and that number. What is that multiple going to be? Is it going to be 5 times your EBITDA? Is it going to be 8 times your EBITDA? Are you going to get 10 times your EBITDA? Do you have great contracts? Do you have very limited liability out there, very limited exposure because you have your policies and procedures in place? We are talking about a tremendous amount of money differential. So for those of you that are looking to hang on to your pocketbook and count your pennies now and not get the stuff in place, you're risking, number one, exposure as you operate, and you are also risking maximizing your value upon sale. So it's very important that we educate ourselves, number one, and then number two, it's very important that we actually get correct policies and procedures in place. That way we can know we're protected. We can't protect ourselves from loss of health information to the extent that any of us could feel absolutely 100% sure it's never going to happen, because we have employees that maybe go home with a laptop. People have information that they email to their cell phones. Things happen. Cars get stolen. Phones get stolen. Laptops get stolen. You bring a laptop in to be repaired. You assume that the place you bring it is professional. They lose it, and there's information on it. I understand that. That's not where the exposure from HIPAA comes in. It comes in if it's not reported in a time frame that's required. If it's a breach of 500 or more people, you're required to tell the Office for Civil Rights within 30 days. If it's a smaller breach that's impacting less people, and we don't think that it's that damaging, you're still required to report within that calendar year. I think you have maybe a little bit of an extension, 30 days after the end of the year or 60 days after the end of the year. So you're required to make a voluntary disclosure. If you do not make the disclosure and the government finds out anyway, and they come in and they see you don't have any policies or procedures on file, you don't have any risk-shifting procedures, you don't have any employee protections, you're going to have significant exposure. And if it happens after you sold, as we talked about, while you were in charge but after you sold, you're likely going to be responsible for paying back that purchaser. So the value that you've maximized by having these great clients and receiving this high multiple is going to be vitiated by the whole of compliance that you've left with your business. Okay, so what can we do? If you need resources, HBMA is your first stop. They have a tremendous amount of information on their website. They do an incredible job looking to educate their members on a regular basis. Obviously, the in-persons are great. You get to have feedback from your other colleagues, and you get to speak directly with whatever resources they've sourced to give you lectures. Hopefully, I'll see you guys soon in one of the upcoming seminars. The webinars are meant to be to fill information for you, so that way you're always continuously being educated. And HBMA, I applaud them. They're one of the best associations out there. They do an incredible job. If you're looking for assistance from our firm, you can call me anytime you want. I will give you my information next. We are an HBMA MVP participant, and we do provide benefits to HBMA members. Here is our website, kirschenbaumesq.com. We have a prepaid legal plan, which many of you, this is more for providers. And then we have standard form contracts. This is not the type of, we have a billing service contract on here, but that's a bare bones contract. It does have protections, and it has a schedule for you to fill in all the services. It's comprehensive, but it's not necessarily one that's been customized for your practice. It's a standard billing form. If you are looking for our assistance and you're an HBMA member, we offer discounted legal fees, a free initial consultation. That would be on the phone, or if you want to come to our office, you're more than welcome to. We anticipate the free consultation would be 30 minutes, maybe an hour at most, not 3 hours. So if you plan on bringing in every document you've ever filled out with a client and an employee, we'll have to think about that, but I don't think that's going to count as initial consultation. 15% off customizable compliance forms, and just let us know that you're an HBMA member. So with that, I'm going to put up my contact information. Here's what I do, and you can reach me at this email address. And if you want to sign up for our bi-weekly newsletter, you can do so on our website. Lindsay, that's the information I have for today. I'm going to check and see if we have any questions. I don't know if you do.
Thank you so much, Jennifer.
Sure.
As of right now, we haven't had any questions come in. I know you had quite a lot of great information. So, folks, if you do have any questions, I know we're coming up on the end of the hour, but please do submit those just here in the next minute or so through the question tab in your GoToWebinar dashboard. And as we're waiting to see if any questions do pop through, I just wanted to say thank you so much, Jennifer, for all of your presentation, or all of your information in today's presentation, and thank you to all of our attendees who were here and participated in today's program. All right.
Thank you, Lindsay, for having me.
Yeah, thank you, Jennifer. We got some questions that just popped in. First one is, do you need two different business associate agreements, one for the client and one for our vendors, if and the person who's asking mentioned that they are a billing company?
One for the, well, we need a business associate agreement with our client. Do we need a business associate agreement with another vendor, and is it a different type of agreement? Typically, there are there are changes. If you're talking about if it's a subcontractor, or you as a billing company are looking to work with a different type of arrangement than necessarily one of your clients, there are usually minor changes to the business associate agreement. So it's more of like a 2% modification to the contract, not a full gut job. It's very similar provisions, but yes, we do modify a couple of things here or there, mostly the references, and then also the risk shifting provision, which is the indemnification provision. So we do recommend looking at that and having generally on hand two different types, one for clients and then one for subcontractors or vendors.
All right, great, thank you. And the other question that we had is, are you able to help with issues in other states?
Yes, absolutely. We do help with contract issues nationwide and litigation. We do serve as counsel all over the place, actually, and we consult on matters actually nationally, but cases where we're regularly filing for lawsuits mostly is New York, New Jersey, and Connecticut. But if anyone has a question that's an HBMA member that I cannot serve as a counsel for on the issue, or if I genuinely believe that it's not going to be the most convenient for you or the best case for you, if we can get you better assistance somewhere else, which I'm happy to say, we don't need to take on more than we can handle, and certainly we're not going to do what's not in the best interest of our client. As an HBMA member, I'm available to you, and you can call me with any issue that comes up, and if I'm not the right person to help you, I will tell you that, and I will help you find resources.
All right. Well, great. Thank you so much, Jennifer, for all of your info and for being so open to having HBMA members reach out to you. I know your expertise is invaluable for our membership. Since we are a couple minutes over the hour, we'll wrap up at this point. So thank you again, and everyone, please remember to visit the Education on Demand page at hbma.org for the recording of today's presentation. And we'll also be sending out a brief survey evaluation, so please do take that. We would love to hear your thoughts on both this program and other programming that HBMA can provide to better serve you. And if you have any other questions, or if you are not an HBMA member and you would like additional information on joining, please don't hesitate to contact us at info@hbma.org. Thank you again to both Jennifer and all of our participants for attending, and have a great rest of your day.